This is the third and final lecture in the series covering litigation in comparison to the arbitration process. I'm going to pause for a moment and talk about motion practice. And motions can really be filed at any point throughout the case, from the very beginning of a case where a party might file a motion to dismiss the case for lack of jurisdiction or failure to state a claim, to throughout the discovery process where a party might file a motion to compel discovery if the other party's not complying voluntarily, or in the actual trial, a party might file a motion to strike certain evidence. The motions that are most important are what are called dispositive motions, though. Those are the ones that seek to actually dispose of a claim. We mentioned two already, the beginning motions to dismiss for lack of jurisdiction or failure to state a claim. Then there's also what's called the motion for summary judgment, where a party seeks to have the court determine that there is no material fact or issue to be tried, and therefore, as a matter of law, the case must be dismissed. You usually see this at the conclusion of a party's case on its claim in chief. Motions are commonly filed in litigation. 15, 20, 30 years ago, they were never filed in arbitration, or rarely filed. As arbitration has brought in more of the elements of litigation, because the parties want the protections that they feel they have in litigation that were not there in arbitration, motion practice is a little more commonplace in arbitration. And think back to the rules of providers like AAA and JAMS. There generally are broad provisions within those rules that allow the arbitrator to entertain motions. And parties could also expand on this practice through their arbitration agreements, or the parties and the arbitrator could work through this at the preliminary hearing. In general, though, arbitrators and even counsel do try to minimize the formality of motion practice in arbitration, to distinguish it a little bit from litigation, but also to make it more efficient, because there is more flexibility and the parties are not required to adhere to the formal rules of civil procedure as they would be in court. So motion practice and arbitration may be done more in the form of letters. It might be done just by oral argument on a conference call or a Skype call, or even at a hearing. With all of the push for arbitration to become more efficient and less like litigation, there is substantial pushback against extensive motion practice being used in arbitration. So it's important to know that it can be done in both procedures, but it is more informal in arbitration and it is less popular, although still fairly present in arbitration. One of the other big distinctions between arbitration and litigation is the appeal process. And an appeal, even in litigation, is not a rehearing on the merits of the dispute. Let's talk about it in the context of litigation first. The party who lost at trial is called the appellant, and the appeal is the appellant's request to the court to review the lower court's decision for what is called reversible error. And errors are mistakes in law as applied by the court. For example, if a judge at the trial level allowed evidence that by the rules of evidence should not have been admitted and either considered by the judge or allowed to be considered by the jury, that gives a non-prevailing party the ability to file an appeal. Now, it's not an automatic right that they win. The court then must listen to the party's argument about that error to establish, A, that there was an error, and if the error caused substantial prejudice. If that is found, then the appellant wins on its appeal. Now, if the appellant wins, there are some choices in remedy, and part of the appellate filing is the appellant should state the remedy it is seeking. An appellate court can order a whole new trial, and that is done at the trial level. So it's not the appellate court that rehears the merits of the case. It is the appellate court that decides if there is an error of law, and if there is a new trial, sends it back down to the trial level. Or it can order a correction or modification of the lower court's ruling. Some appellate courts could also make that correction or modification on their own. One might be, for instance, if there was a statute which dictates how damages are to be calculated, and on appeal, the appellant proved that that was inappropriately applied, that could be sent back down to be corrected with instructions as to how to apply that law. There's also an order for reconsidering facts or taking of additional evidence. So those are the sources of remedy under an appeal. Now, if the appellant loses and the appellate level finds in favor of the party who won at trial level, there are two courses of action. Depending upon the court system, the losing party might try for a second level of appeal. And again, the higher up you go in the appellate system, the harder it is for that party to convince the court that the issue should be heard again. If there is no second right of appeal, or the higher level of appeals court rejects the appellant's request for a second appeal, then the case is over. Now, let's distinguish that from arbitration. Technically, there really is no right of appeal in arbitration. A losing party may move to vacate the arbitrator's decision, the arbitrator's award. Moving to vacate is not the same as an appeal. You are not looking for reversible error. Remember that an arbitrator or panel of arbitrators can make a mistake in the application of law, and that does not give the losing party the right to have that alleged mistake reviewed and have the case retried or have the error corrected. Really, the only reasons a party under the statutes, both federal and state, that govern arbitration, the reasons a party can move to vacate are proving fraud or bias or corruption on the part of the arbitrator, or at a very, very high level being able to prove that the arbitrator failed to admit material evidence. Parties moving to vacate arbitrators' awards are not very common, and very few are granted. You hear a lot of stories about them, but they really, in comparison to appeals of litigation, aren't nearly as many. In recent years, parties who like all of the other benefits of arbitration but are concerned about the lack of appeal and the possibility of a final decision where an arbitrator has made a mistake have lobbied for the creation of appellate arbitration rules. The American Arbitration Association and JAMS have created these in the recent years, but the only way they apply is if the parties agree to use them, and that normally has to be written into the original contract, which is the source of arbitration. Just think it through. It is unlikely that the parties are going to agree to an appellate arbitration process once the arbitrator's award has been rendered. The winning party is not going to see any value to doing that. So only if the parties write the appellate arbitration rules of one of the two providers, or they could craft their own appellate process. That's a possibility, but without that being in the party's original source of arbitration, there is no right of appeal that is directly equivalent to the right of appeal in litigation. So let's take a final review. Jurisdiction. Generally, parties can get into court more easily than they can get into arbitration. You need a contract requirement or a statutory right to get into arbitration. In court, you do need standing. You have to have a stake in the dispute, and you have to have a court which has the appropriate level of jurisdiction. Pleadings, the rules of procedure, the rules of evidence are much more complex in litigation, and failure to follow them usually have more stricter consequences. Arbitration, pleadings are much more flexible, and the rules of procedure and evidence are not really even codified the way they are in litigation. There is general guidance in rules of providers. Parties could write requirements into their arbitration agreement, but there's a lot more flexibility to craft the structure of the process. Decision maker, you have a subject matter and process matter expert in arbitration, and the parties generally have a fair amount of control to exclusive control over who that person or group of persons is. In court, you have a process expert in the judge and may or may not have subject matter expertise. It's always going to be substantially less in terms of subject matter expertise than it is in arbitration. Finality of the decision. Arbitration awards are much more final than litigation, with the possible exception of that right of appeal that has to be agreed to in the contract. Arbitration, also keep in mind, is private. If there is a need for precedent and public precedent, then litigation is the better option. Privacy, though, it can be very important to businesses. And then there's the cost. On smaller to average size disputes, arbitration generally wins in terms of the argument on cost and time. In the more complex cases, arbitration and litigation can be the same. On rare circumstances, arbitration might be more expensive, sometimes because of that greater degree of flexibility. But in general, and with parties who are thoughtful and knowledgeable about the process, and with well-trained arbitrators, arbitration, even in the most complex cases, is still usually a little bit faster and a little bit less expensive. And that concludes the comparison of litigation to arbitration.